Ready? Start. A division bench of Delhi High Court in Commissioner of Wealth Tax versus H.S. Chauhan within bracket 2000 245 ITR 704 again referred to provisions of sections 14, 15, 17 and 19 of the WT Act as they existed and were applicable for the assessment years 1960-61 to 1971-72. Stop. It was held that these provisions have no applicability to proceedings relating to imposition of penalty against the legal representatives. Stop. The provisions as existed penalty under section 18 did not come under the ambit of section 19 of the WT Act. Stop. It was further held that Section 159 of the IT Act had a clear prescription for continuation of proceedings for imposing penalty against the legal heirs, but Section 19 of the WT Act was contextually different from subsection within bracket 2 to Section 159 of the WT Act. Stop. Para. Jurisprudentially, the person is actionable and responsible for himself for what he does and not for what others do or for events or acts of others. Stop. Family per se or a spouse is not actionable or responsible for any other family members or for the spouse. Stop. Doctrine of vicarious liability is not of general application and is applied in cases of statutory crimes. Stop. For detailed elucidation, refer Central Excise Act. Stop. Reference 1 of 2011 Freeze Air India within bracket P Limited versus Commissioner of Central Excise Delhi. Stop. Normally, there are specific provisions in the statute which imposes an obligation which are invoked to fasten vicarious liability. Stop. Bombay High Court in Controller of Estate Duty within bracket Central Bombay versus NH Kotak within bracket 1982 134 ITR 256 had the occasion to consider the question whether penalty levied under the IT Act on a firm of which the deceased was a partner should be deducted in determining the value of the property passing on the death of the deceased. Stop. The debt it was opined means a sum of money which was now payable or would become payable in future by reason of a present obligation debitum in praesenti solvendum in futuro. Stop. Thus, the fact that the amount was to be ascertained does not make it any less a debt if the liability was certain. Stop. However, liability qua penalty arises only when an order imposing penalty stands was passed by the appropriate authority. Stop. Until then, there was no liability whatsoever. Stop. Thus, liability to pay an amount by way of penalty cannot be equated or compared with tax liability, which remains certain though may be quantified at a later date. Stop. Over.